Welcome to Literary and Jury Charge Practice. Let's get started with a jury charge, and the subject is real estate condemnation. Ready? This being the time and place set for the hearing of this matter, comes now the plaintiff by Donald Robin, its attorney, and come now the defendants, Henry Thomas and Dorothy Thomas, his wife, and appear herein by and through their attorney, Arnold J. Roberts, and said defendants, Thomas and Thomas, now file motion to separate paragraph 1 of the complaint from the balance of the complaint, and to separately docket the same as a separate cause of action. And come now the defendants, Claude Hilton and Laura Hilton, his wife, and appear herein by their attorney, Charles R. Pearson, and move that paragraph 2 of the complaint be separated from the balance of the complaint and separately docketed as a separate cause of action. This being the time and place set for the hearing of this cause, come now the plaintiff by its counsel, and come now all other defendants by their respective counsel, and this cause is submitted to the court for trial. And the court examines the complaint and hears evidence thereon, and is satisfied that the plaintiff is entitled to condemn and appropriate the real estate described in the complaint for the purposes therein set forth, and that the material allegations of plaintiff's complaint are true, and that the plaintiff is entitled to the relief therein prayed for. It is therefore considered, ordered, adjudged, and decreed by the court as follows. 1. That the defendants, Henry Thomas and Dorothy Thomas, his wife, are the owners in fee simple of the following described real estate in Sumter County, to wit, a parcel of land known as Lot 9 in Norwood's unrecorded subdivision of the east 1/2 of the southeast 1/4 of Section 14, Township 36 North, Range 7 West, Sumter County, to wit, commencing at an iron pipe, as now located at a point 2066.3 feet north and 18.4 feet east of the southwest corner of the said east 1/2 of said southeast 1/4 section, and running thence north 105.6 feet to an iron pipe, thence east 437.88 feet to an iron pipe, as now located on the west line of a public highway. Thence south along said west line of said public highway 105.6 feet to an iron pipe, as now located thence west 437.67 feet to the point of beginning, containing 1.10 acres more or less. Also a parcel of land known as Lot 12 in Norwood's unrecorded subdivision of the east 1/2 of the southeast 1/4 of Section 14, Township 36 North, Range 7 West, Sumter County. We'll get back to that one. We may take that in bits and pieces. Try this one. subject of this jury charge is Federal Tort Claims Act. So let's do a part of this one for practice. Ready? The scope of this case, although it involves a general act of Congress, is geographically constricted. The holding is applicable only to actions under the Federal Tort Claims Act arising out of wrongful deaths in Massachusetts. The court, finding the words of the Federal Tort Claims Act so clear, reverses the judgment of the Court of Appeals, which has special responsibility for interpreting federal law in matters unique to its circuit. Underlying the court's reasoning is the belief that the language of the 1947 amendment is so clear that it would require creative reconstruction of the amendment to limit the amount of the judgment to the maximum recoverable under the Massachusetts Death Act. On more than one occasion, but evidently not frequently enough, Judge Hand has warned against restricting the meaning of a statute to the meaning of its plain words. There is no surer way to misread any document than to read it literally. Of course, one begins with the words of a statute to ascertain its meaning, but one does not end with them. The notion that the plain meaning of the words of a statute defines the meaning of the statute reminds one of T.H. Huxley's gay observation to the effect that at times a theory survives long after its brains are knocked out. The words of this legislation are as plain as the court finds them to be only if the 1947 amendment is read in misleading isolation. An amendment is not a repeal. An amendment is part of the legislation it amends. The 1947 amendment to the Federal Tort Claims Act of 1946 must be read to harmonize with the central purpose of the original act. The central purpose of the original act was to allow recovery against the United States on the basis and to the extent of recoveries for like torts committed by private tortfeasors in the state in which the act or omission giving rise to the claim against the United States occurred. The 1947 amendment filled the gap, a very small gap, that was disclosed in the scheme formulated by the 1946 Act. All right, let's do some literary practice now. And the subject of this literary is giving back. Ready? In 2016, the Community College of Allegheny County, CCAC, in Pittsburgh, Pennsylvania, celebrated its 50th anniversary. The court reporting program at CCAC began in 1967. On October 5, the college held a CCAC Allegheny campus through the decades presentation with CCAC alumnus Robert Bob Mill, a member of the first CCAC class in 1966, as the keynote speaker. Another CCAC alumna, Connie Lee RPR, a freelancer in Pittsburgh, volunteered to caption the event. Connie's captions are nearly flawless, says Mary Beth Johnson, CRI, an instructor at CCAC. She wrote for nearly an hour material that ranged from a story about a kid stealing molasses to Mr. Mill recalling the names for his favorite professors, none of which Connie had in her dictionary, so she meticulously finger-spelled each surname. What is most significant to me is that Connie is an accomplished court reporter, Johnson continued. Yet Connie saw fit to give back to her alma mater in the middle of a Wednesday afternoon when she could have accepted a paying job. She demonstrated to our students who were in attendance the value of community service. Connie also served as a role model. She sat in the very same classroom with the very same teachers. Connie was always at the cutting edge, from starting CART at Carnegie Mellon University to launching a successful freelance agency, captioning at Vitek and for the Penguins, and writing with ease and determination captions at CCAC. The JCR caught up with Lee to talk about how her career has progressed since a student. She reflected on her time at CCAC, starting out as a freelancer and getting into captioning, learning at CCAC. When I graduated high school, I was working at a fast food restaurant. My sister was the delivery person for Powers and Garrison, now Powers and Garrison and Hughes, a court reporting firm in Pittsburgh. She was promoted, and so she asked me if I would like a full-time job assembling and delivering transcripts. Turned out to be the best career decision of my life. I felt very lucky when years later I decided to become a reporter and realized CCAC had the program. That meant I could actually afford to go to college. I needed to pay cash for college, and this meant I could. Obviously, my favorite memory from court reporting school is getting that last speed take. I'll never forget the first day either. I was standing in the room listening to Mary Beth Johnson give 225 takes to the second-year students. I just started to laugh because I couldn't even hear that fast. I also remember that I hit a hard wall at 180. Bill Weber, RDR, CRR, was my night instructor, and he dictated a 190 warm-up for yet another 180 take, and I looked at him in shock. I said, "I think I got that 190. He smiled and said, "Then write it up." I totally skipped 180 and went on to 190. I had finally broken through that wall. I always try to help out Mary Beth at CCAC with anything I can. When she asked if I could perform CART for the 50th anniversary celebration, I was happy to do so. It was the most gratifying experience. Not only did I get to show off my skills, but I was able to do it for the institution that helped me achieve my career goal. As I listened to the speakers talk about the first class's responsibility to the community who brought them this opportunity to further their educations, it reminded me of all those who paved the way before me to make sure that I too would succeed. I felt very humbled and grateful. Right, we'll have to get back to that one. Let's practice a little more of our jury charge. All right, here we go. Ready? The gap was the situation revealed in two of the states, namely Alabama and Massachusetts. When the Federal Tort Claims Act was passed, the death acts of both Alabama and Massachusetts provided for assessment of the defendant's liability for damages on a punitive basis. In Alabama, however, there was no maximum limitation on the recovery, and the problem of this case namely whether a recovery in excess of the statutory maximum recoverable against a private employer can be had against the United States, is therefore unique to recovery against the United States under the Massachusetts Death Act. In filling the gap, Congress was concerned only to provide for recovery against the United States for wrongful deaths in Massachusetts and Alabama, and to provide for recovery, as did the original act, on a compensatory, not a punitive basis. There is nothing to indicate, and it is unreasonable to suppose, that Congress meant a recovery in Massachusetts to be unlimited in amount in the face of the state's statutory limitation, at the same time that recoveries in the dozen other states with statutory limitations would be restricted. Such a construction does not merely take Massachusetts plaintiffs out of the general scheme of the Federal Tort Claims Act. It does so by putting them in a better position than plaintiffs in the dozen other states with statutory ceilings. This imputes to Congress a desire to correct the inequity in the 1946 Act by creating an inequity in the 1947 Amendment. Of course, the Massachusetts limitation is contained in a statute in which damages are related to a punitive rather than a compensatory basis. The purpose of the 1947 Amendment was to allow recovery against the United States when the governing state statute measured damages on such a basis, with this sole exception that the state statute puts the recovery on a harsher basis. The state statute is the governing statute. It may well be that if Massachusetts were to enact a statute restricting recovery to compensatory damages, it would impose a different ceiling, but that is no reason to reject the ceiling in its present statute. It does not comport with good sense and reason to suppose that a state would impose a higher ceiling on a recovery based on compensatory damages than it does when it allows punitive damages. This common sense assumption is supported by the fact that during the brief period from 1947 through 1949, when the Massachusetts statute did measure damages solely on a compensatory basis, the ceiling was fixed at $15,000. This was the same ceiling that was in the previous statute, which measured damages on a combined punitive and compensatory basis, and the same ceiling that was in the immediately subsequent statute, with measured damages solely on a punitive damage basis. To deny effect to this common sense assumption is to elevate the literal reading of the 1947 Amendment above the central basis of the Federal Tort Claims Act, the assimilation of recovery under federal law to recovery under state law. All right, let's get back to our literary. And this section is called Going into Business as a Freelancer. Ready? Since I had been employed at Powers and Garrison straight out of high school, I was so very fortunate to learn from the ground up all the different aspects of running a reporting business. Before I became a reporter, I was also the office manager at Steffen and Stauffer for 7 years. I repeatedly tell students to work at reporting firms as the delivery person. By the time I became a reporter, I knew exactly where all the firms were and how to get there, and I was already friendly with the receptionist and some of the attorneys too. I started my current company, Constance Lee and Company, about 11 years ago. When I left captioning, I hired my first employee, Liz Cap, about a year ago to manage the office so that I can actually get some sleep at night. Liz is invaluable to me. I am the only full-time reporter, but I contract out to about 13 reporters. I have offices in both Pennsylvania and West Virginia, and I am an Illinois CSR. I would say there are two things we do well here: customer service and growing without debt. We view ourselves as the Robin to our clients' Batman. We are not the superstars they are. It's our job to make the attorneys look good. My husband and I have drawn a line in the sand to never ever carry debt, and I've taken the same stance in my business. Being debt-free and having retained earnings enables me to not experience the roller coaster ride that is the freelancer's paycheck. I pay myself a salary, so my life is more stable, thus creating a peace that enables me to take chances. I'm not afraid to fail at an idea because I have a safety net. All right, that will conclude our literary injury charge practice.